Joining me now, Alan Dershowitz, Professor Emeritus at Harvard Law School and author of Trumped Up, How the Criminalization of Political Differences Endangers Democracy, and Bob Bauer. He's a former White House counsel to President Obama. Gentlemen, welcome to both of you on this spring holiday season. Mr. Dershowitz, let me start with you, and I want to pick up on something we learned this week from a New York Times report. The now former lawyer to the president, lead lawyer to the president, John Dowd, who ended up resigning last week. There were reports that he talked of pardons, potential pardons with the attorneys of Michael Flynn and of Paul Manafort. If that pardon was dangled out there, in your opinion, could that be used in an obstruction of justice case?
Look, I think there are three categories of cases that are being investigated. The first and most important are constitutionally authorized acts by the president, which include pardoning, offering pardons, firing, directing the prosecution. If he were ever to be charged or impeached for any of those acts, that would be a real constitutional conflict, and we'd have arguments on both sides constitutionally. The second category are purely private acts that preceded his presidency, the allegations by women that may require him to testify under oath, his business relations. He'd have no defense for that except factual, or he could argue that it was beyond the scope of the investigation. And then there's the third category, a hybrid category, including emoluments, whether there was collusion. Those are the three categories. I do think that anything relating to pardon, he would have a strong constitutional defense. I think he's most vulnerable when it comes to women if he testifies under oath and gets into a she said, he said, which puts him in Clinton land and the basis on which Clinton was impeached.
Mr. Bauer, what do you say on the pardon issue?
I don't think there's any question, and I have to respectfully disagree with Professor Dershowitz. If the president uses the pardon power for a corrupt purpose, then he's exposed to criminal liability for that. If his lawyer, with his authority on his behalf, offered a pardon as a means of tainting or corrupting testimony in a criminal proceeding, then I don't see any basis for saying the president does not have to answer for that in the criminal justice system.
But if the president believes that this investigation is trumped up, that Mr. Mueller's investigation is out of control, then why wouldn't he offer pardons?
Well, he may believe that, but he may also believe it's out of control because he fears for himself, because he's concerned about his own exposure. And it's precisely that element of self-protectiveness that I think threatens the legality of that offer of the pardons, that brings that into question.
Go ahead.
There's a real problem with that, and that is President Bush, the first, did exactly that. He pardoned Caspar Weinberger and 5 people on the eve of the trial in order to end the investigation. And special counsel at that time, Lawrence Welk, accused him of doing that and said he had succeeded in ending the investigation. And yet nobody suggested obstruction of justice at that point. Thomas Jefferson gave pardons to people in order to help the prosecution of his political enemy, Aaron Burr. All throughout history, we see presidents offering and granting pardons. Once you start getting into the area of inquiring as to what the motive of a pardon was, you're really getting into constitutionally difficult areas. Of course, if the president were to take a bribe and give a pardon, the taking of the bribe itself would be the crime. The granting of the pardon would not be a crime. I do not believe that engaging in a constitutionally authorized act can ever be the basis of a criminal charge.
All right, I want to move the conversation here a little bit, and Bob, let me start with you. The fact that Flynn decided to cooperate and plead guilty and not accept the dangling of a pardon, ditto with or does that tell you something? And does Paul Manafort's decision not to cooperate tell you something with this pardon? What do you read into it?
I don't know that I read a whole lot into it. I mean, it may be that Mr. Flynn just wasn't confident that the offer of the pardon was something he could count on. Who's to say why he would have done that? But if I could, again, disagree with Professor Dershowitz, the Iran-Contra matter did involve potentially questions of high policy, but I don't see that here at all. What's at issue here is whether or not a presidential campaign coordinated with a foreign power to affect the outcome of an election. And that is a core criminal concern. It's been part of our statutory framework since 1966, repeatedly strengthened by the Congress. And I don't see that that bears any analogy at all to Iran-Contra.
Well, except that the pardon was offered to stop a criminal investigation by a special prosecutor. Under your theory, that would be obstruction of justice, and yet it never occurred to anybody. It doesn't matter what the subject matter was. If you obstruct justice for any subject matter, you're guilty. The issue is whether granting a pardon in order to stop an investigation can be the basis for criminal or prosecution. And I think the answer to that precedentially is no, and it's no justification to say that involved matters of high policy, and this involved matters of the Soviet Union, relationship with the Soviet Union. That's not a good argument.
You guys are two very bright legal minds, but there is no legal standard for impeachment.
There is a legal standard.
Is there? So
yes.
It doesn't matter what you interpret as obstruction of justice, what Bob interprets as obstruction of justice. At the end of the day, it's about what the members, what 100 members of the United States Senate think.
I don't agree with that. The Constitution provides specifically you can only be impeached for bribery, treason, or other high crimes and misdemeanors. They also put the Chief Justice in charge of the trial. And if I were ever, or any of the lawyers for Trump, if he got impeached for something that was not specified in the Constitution, the first motion that should be made is to the Chief Justice to dismiss it on legal grounds. This is not purely a political decision. Otherwise, the Chief Justice, who's not political, would not be put in charge of the trial of a person who's been impeached. So I think it overstates it to say it's completely political, unbound by the words of the Constitution itself.
Mr. Bauer?
Can I just bring this back to the criminal justice system? But you're absolutely correct. I mean, Congress certainly could act on an obstruction that didn't quite fit the criminal elements in the law, but still was enough for impeachment. But let's be clear again what we're talking about. We're talking about the potential that a presidential campaign in the United States aided a foreign government in influencing the outcome of the federal election. That is a crime. It is a crime. It is not correct, as Professor Dershowitz has said from time to time, that collaboration with a foreign government to help in an American presidential candidate's election is not criminal. It is.
What's the statute? What's the statute?
The federal election
I've searched the statute books over and over again. The word collusion appears once in the Federal Criminal Code. It only applies to when businesses collude with each other in violation of the antitrust laws. Collusion between a candidate and a foreign government is a political sin. It would be a terrible thing to do. But in and of itself, it wouldn't be a crime. Of course, it could involve criminal activities if you accepted campaign contributions and did things of that kind. But the collusion itself would not be a crime if it occurred. And I've seen no evidence that it has occurred.
Very quickly, Professor Dershowitz, the president wants to talk to Mueller. At least he says so. What parameters would you advise him to accept?
Any he can get. I mean,
would you advise him to do it?
First of all, Mueller has the ultimate authority to call him in front of a grand jury without his lawyer and no limitations on time. So he has to come to a compromise. I would surely suggest that he never testify in any of the cases involving women, that he not make the mistake that Bill Clinton made, advised by Bob Bennett, that he testify about his sex life. But as far as the special counsel is concerned, he doesn't control that. The special counsel controls that. So any compromise that can be made sitting with his lawyer, it doesn't matter whether it's under oath or not, because either is a crime. But constraints on time, constraints on subject matter, anything he can get would be a plus, because the special prosecutor has the power to call him in front of the grand jury.
Very quickly.
Very quickly, I would simply say, since Donald Trump may have known that the Kremlin sent emissaries to his campaign in June of 2016 to talk about support for his campaign, he might take the advice that he gave Bill Clinton in 1999, take the fifth.
Very interesting. Professor Dershowitz, very quickly, any chance you'll lead the president's legal team or join it in any capacity whatsoever if he asks?
No, I want to remain independent. I want to say what I say. I want to say what I said about Hillary Clinton.
Has he asked you to join the team?
You know that no lawyer can ever comment about whether he's ever been asked. But let me say, I would have said the same thing if Hillary Clinton had been elected president and they were saying lock her up. I'm making exactly the same position now that I've made for 50 years as a civil libertarian.
Professor Dershowitz, I appreciate you coming on during this holiday week. Much appreciated. Hey, NBC News fans, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here, and then click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.